Good evening, everybody. Hope you are all doing well. This is Jonathan Ginsburg. It is July 22nd, 2026. Hard to believe we are already in third week of July 2026. The weeks just keep zooming by, but that's I guess that's what happened when you're having a good time. So anyway, I hope you're all doing well, staying cool. We are going to talk about a lot of different things tonight. I've scheduled to have a guest. Attorney Jeffrey Herman. I don't see him in the waiting room yet, but hopefully he will appear along with a paralegal in his office. Hopefully they'll make it. If not, we'll do it another time, but hope that they do appear because Jeff's a good friend of mine, and hoping we can get into some interesting questions. It looks like they have arrived. His paralegal, Sydney, is here, it looks like. So I'm going to go ahead and add Sydney to the stage. Sydney, how are you doing?
Hi, Jonathan. I'm doing well. How are you?
I'm doing great. I was just telling everybody I had you scheduled for tonight. I didn't see you. I'm hoping you come, but I'm glad you did. So, if you've had a chance to watch a couple of these, what we do is we answer questions from folks about Social Security things. But, I always like to do when I have a guest, I kind of go through just a couple of things that I thought were just kind of on my mind. I'd just be curious to how you might answer some of these questions. And I guess, I know, well, actually, before we do that, tell us about you. And I know you just got your EDPNA certification, which means that you are authorized now to try cases. First of all, tell everybody what an EDPNA certification is.
Yes. So that allows non-attorney reps to represent clients in court. It means that as long as you pass the EDPNA exam, you are authorized to do so. You do have to have a couple of other requirements in order to take that exam. However, one of those requirements being a 4-year degree or 4 years of relevant experience. You can have one or the other or both.
Okay. And obviously, it looks like Jeff has arrived as well. So let's go ahead and add him too as well. Jeff, how are you doing?
Doing great. How you doing, Jonathan? Good to see you.
I'm doing good. And Sydney is here as well. We're just talking about what a EDPNA certification is. And she was telling us what that means. And obviously, the thing about Social Security, which is kind of unique, is that you don't have to be an attorney or a rep or have any qualifications, formal qualifications to handle Social Security cases. I think people that don't, they have their next door neighbor or the kid down the street, they're asking for trouble. And as Sydney was saying, when you go through the certification, you have a test, at least you have, you've done this in 4 years of college or 4 years, but I suspect most people, it's 4 years of experience. And that really goes a long way to helping people know what they're doing, because this is not a practice area you can dabble in. That's my feeling. I suspect you feel the same way.
I certainly do. I agree 100%.
All right. So what I'd like to do is, since I have both of you here, let me find my notes here, which I'm having trouble. Oh, okay. Just a couple of things I just wanted to ask. And I a lot of times I'll ask people who are in practice. Let's just talk about preparing people for a hearing. And I don't necessarily want to, I mean, we all talk about, what the judge is going to say, the phone's going to ring and the judge is going to ask you your name and things like that. That's not what I'm talking about. What's the approach that a client or a claimant should take? For example, I always tell my clients, never have an attitude of entitlement. Never feel like you've decided you're disabled and, you just want the judge to verify that you feel, that you're entitled to disability. Or a second thing I always tell people is, let the judge know, hey, if I could go back to work, I would. I think that really enhances credibility. Are there things like that that you tell your clients to sort of help them establish a rapport with the judge, to show that they're motivated, they have the right mindset?
Yeah, that's a good question. We, as a firm, we follow like an overall outline when we prepare every client, so that from top to bottom, we do have a system in place. And among some of the tips we give, we always tell clients that, number one, be respectful of the judge when you do address the judge in your honor. Number two, we always encourage our clients to Don't let their personal pride or other feelings about the government or the system get in the way of their disability claim and really the truth of the nature of their limitations. We always tell clients, don't sound like you're reading from your notes. The best responses are the ones that are more natural and candid, and you're really just being honest with the judge. We also tell a client that, everybody, no matter what they're going through, they have good days and bad, but you should try to climb into the mindset of it being a bad day when you do provide answers to the common questions that arise. It's kind of a fine line. I don't know how you find, Jonathan, and we know it's an informal proceeding, but still their testimony does matter. So I don't want to lull a client into a false sense of, because it sounds informal, maybe they can get overly conversational.
Yep.
Generally speaking, in law, the more you talk, the more you give yourself some rope to hang yourself with. So we still want, we want our clients to take this as serious as possible.
Yeah.
And we don't need to tell them that. They already know, but don't let the informality of the proceeding lull you into a false sense of, overconfidence or oversharing, I would say.
Okay. I think that, one of the things I have people sometimes will say as well, my meeting is scheduled for, next Tuesday. It's not a meeting, it's a hearing. I mean, this is it's an administrative law judge hearing, but this is a judge. It's not a judge like you'd see in state court, but this is a judge, and it's your honor. And, I've had a couple of clients over the years try to make jokes. This is not a place to show you're a frustrated stand-up comedian. Most judges are not looking for a chuckle. And you got to just take it very, very seriously. And one of the points you made, I think it's really important for everybody to understand is, 2 points you made. One is, don't be a hero. I mean, especially for men, it's very hard if you've been, you've played football in high school, you're very athletic, to say, I can't lift 10 pounds. Or people, so I could probably lift 30 or 40 pounds, but you got 3 herniated discs. You really can't lift 30 or 40 pounds. I think that's something you have to just really come to terms with, that you don't want to over exaggerate, but you don't want to exaggerate what you can do, because many times you really can't do it. And the second point is, when you talk about what you could do, this is not if a gun was at your head. You could do it one time and then you'd be in your bed for 3 weeks. This is doing something physical. Let's take the physical part of it, day after day, week after week, month after month. That's what you got to really focus on, because otherwise I think you just, you're going to give the wrong impression. And, you have to be truthful. But on the other hand, you don't want to exaggerate. I had a case several months ago. Judge says to my client, how much can you lift? Oh, about 1 pound. And the judge is like, no. Are you sure that's what you want to say? Kept asking him. Just 1 pound. He asked me 4 times. You sure? And finally, my client got the picture. It's like, okay, maybe 4 or 5 pounds. By then, the damage was done, and it just did not have any credibility there. Right. So, that is certainly an issue. And one thing we didn't talk about, by the way, is your firm, Desert Disability. You're in the Phoenix area, if I'm not mistaken.
That's correct. Yes. Okay.
Do you do cases outside of Arizona, or just pretty much in the Southwest? Where does your practice maybe focus?
We do. I mean, we got a trickle of clients through other Southwestern states, Utah, California, Nevada. And then, as you know, the disability process does take time. So a lot of our clients wind up moving out of state when they start here in Arizona. So basically the Southwest area, though, we do get some clients in.
Got it. All right, Sydney, I know you obviously have worked with Jeff for a while. Let me ask this to you, because this is a question that comes up a lot in my practice. Back pain cases, that's the most common reason people file for disability. What separates a winning back pain case in your mind from one that is it's just too mild? It's not gonna move the meter. What's your take on that?
And what do you mean by back pain case? Are you saying a case
back pain, spinal
back
injury.
Pain?
Yeah, I'm sorry, back pain, back, neck, things like that. Because we see a lot of people, they come in, I've got a bad back, and it could be a herniated disc, it could be a bulging disc. What's your take on how do you differentiate the winners from the losers?
Yeah, so I think with back pain, some of the best evidence is going to come from the objective imaging and what the impression and results show. Anytime we see moderate to severe, we know that we're working with a stronger case. Additionally, physical therapy records, if a client has a lot of those, that's a great way to determine if the case is strong or not, because they're constantly testing their functional limitations when they go to PT. So I would say those two things.
Okay. Yeah, I think physical therapy, that's actually a very good point, because physical therapists are focused on functionality, which is ultimately what the issue in a disability case is. I would add to that, doctors typically would put somebody, if they have neck, back, lower back, neck, mid back cases, they'll start them out with maybe rest, and then they may go physical therapy, then they may go epidurals or facet blocks or radio frequency ablation, then surgery. So you sort of see that path. And ultimately, if they end up where surgery is the option or long-term pain management, that to me it says that this is a case where the person really is not going to be able to work, because they're either facing surgery. And by the way, as you both know, you don't have to have surgery. You can say, I don't want to take the risk because the implications are, the possibility of a bad result is too significant, or long-term pain management where they're on pain meds. And obviously, if you're on narcotic pain meds, you're not going to be too useful in any kind of job. So I look for that progression. But I think that it's a good point that PT notes are going to really talk about the functionality as well. And Jeff, any thoughts on your mind to add to that?
I agree with Sydney's points.
Yeah.
We look for also any nerve involvement, if there's any radicular pain into the arms or legs. Always encourage clients to get those EMGs or nerve conduction studies to show that. And then, of course, it's, if back is the major disabling condition, then it's looking at the other factors of the case, age, past relevant work, and we can go from the back to find ways to perhaps knock out past relevant work if there's heavy hand use and you got that cervical radiculopathy. So I remember one case in particular, this was many years ago, and the client was over 55 and he was a portrait photographer. And he had, a very severe back condition, but he traveled a bit and he still did some physical activities. And it really was a step 4 case, purely. And we really got into
past relevant work. Could he do past relevant work? Right.
And it was one of those cases where just the unique nature of being a portrait photographer involved a lot of kneeling to frame that camera and all that. And we really had to develop just the additional postural limitations, not just the standard standing and walking and lifting and carrying, but also the kneeling and the crouching that you have to do to be a portrait photographer. And we wound up winning that case, but it really was a very in-depth analysis.
Yeah. Well, and the other thing, everybody, that we talk about this a lot on our live stream, is that Social Security still uses as a resource to determine job requirements or job, functional requirements, the Dictionary of Occupational Titles, or the DOT, which you can look at occupationalinfo.org. It is 40 years outdated. I think it was last updated
77,
in 19, I don't know, Sydney probably wasn't even born when this thing was last updated.
I wasn't even born.
But it's a, just terribly outdated, and, they still use it. And one of the things that I look at a lot is the form that people fill out where they describe what they had to do, because that's, a description of their actual job requirements. And then, that's where the vocational witness can come in, and testify about how something has changed. And you can ask them, being a portrait photographer, that's probably one area where I suspect that the equipment has gotten lighter. But on the other hand, there's more stuff to carry around. So it's probably a lot different. I mean, no question. Back in 1980, there was no digital photography.
Right.
And they probably use natural lights, whereas now they may carry around lights because they're more portable, although the equipment may be lighter. So, very different type of thing. And of course, a portrait photographer in a studio versus one in the field, very, very different things. So that's where you want to really develop that with a vocational witness. And we actually have a question from Haq Assad. Haq is a a regular visitor here, and I appreciate the kind words. He says, hope you're doing well, and thanks in advance. And he said that he's got a hearing coming up, I believe in maybe August or September. He said the ALJ posted the VE's resume, the vocational expert's resume, to his account, or the notice says that they will post it 20 days ahead of time. What's the significance of having the VE's resume posted, and how to use that in my preparation for a hearing? And what if the VE's resume is not provided? So how would you answer that? What do you do, if anything? And I have my opinions, and I'll tell you in a second, but about the VE's resume, is that a relevant factor for you at all?
The VE's resume?
Yep.
I'll be honest. I'll glance through the VE resume. I tend to see a lot of the same VEs repeatedly, so I know what to expect. But if it's a brand new VE, I do look through their resume. I look for the kind of how recent their experience is, and if they have any specialties, and if that specialty happens to be outside of the field of, my client's past relevant work. That may cause me a little, pause and want to prepare, just a couple of questions to the VE before I stipulate to allow them to testify as an expert. But more often than not, I just stipulate to the VE if I,
I was going to say, I kind of take the same approach, is that I think the VEs, I always tell my clients, look, the VE is not there to help you or hurt you. The VE is there to answer questions from the judge. And if the judge asks the VE a question and the limitations are very, very minimal, very mild limitations, that are not work preclusive, the VE is going to say, there are plenty of jobs they could do. If the question is, the person's off task 20% of the day, or, they can't lift more than 5 pounds and there's no transferable skills and they're 55 years old, they meet the grids, then you're probably going to win. So I don't worry about the VE too much. The only time, and I would agree with you, I look at the resume, the only time it gives me pause is if I see a VE whose only experience is in the classroom. They haven't been in the field. They haven't placed anybody. And, one of the things that we notice in doing this is there are different approaches to VE testimony and how to cross-examine them. There's a school of thought in the Social Security, the attorney advocate world, where some people take a very, very aggressive approach in cross-examining the VEs. I mean, the NOSCR Bulletin, there's a guy has a regular column, very bright attorney, has a regular column about how to go after VEs with certain jobs. And, and I think there's a place for that. If the VE is coming up with jobs that are clearly obsolete, you go after them. But I think if you're fighting the VE about, their qualifications or the numbers they come up with, you're rearranging deck chairs in the Titanic. I don't think that it's really all that fruitful to go there, because judges don't like it. These hearings are designed for 45 minutes. You spend 20 minutes cross-examining the VE about their qualifications or how they came up with numbers. I don't know. I'm not sure if that's the best use of your time. Now, again, on the opposite side, there are attorneys who will say, you can, because the VEs may refer to something called the SOC codes, I guess the selected occupational characteristics, and doesn't line up with the DOT. And theoretically, you could have multiple SOC codes for every DOT code. And so theoretically, if the VE gives job estimates of 100,000 jobs, but in fact, they're all concentrated in 1 or 2 SOC codes, and your client's SOC code is a different one, that 100,000 jobs may actually be 1,000 jobs, which is not vocationally relevant. You can get into all that. And again, the argument would be, if you don't raise it at the hearing, it's harder to raise it on appeal. Again, I just think that if you're having to fight a VE over job numbers, you're already behind the 8 ball. Judges are going to find a way to deny the case. And if they're sloppy and they use sloppy VE testimony and it gets remanded to the same judge, they just come up with another reason to deny it. So I'm just not my practice is not to really go after VEs real aggressively. So I would kind of agree. Sydney, when you in training, what do they tell you about VE testimony and how to deal with VEs?
Yeah, so Jeff has provided a lot of different training with the cross-examination, but I agree, you do not want to upset the VE during a hearing. That's probably not going to go well for you, and more than likely the judge is going to agree with whatever that vocational expert testifies to.
Yeah.
So I think it's important to be careful. Reviewing the resume does not make too much of a difference. Like Jeff said, we do kind of glance at it, go through it. But I was curious for you, if you see that a VE has vocational rehabilitation on their resume, do you feel like they're going to be more supportive for the client because they understand them better?
I don't know. Again, I have never found VEs to really have an agenda. That's been my experience. I mean, most of them are there to provide testimony, to answer questions from the judge. Every once in a while, you'll hear a VE, you can kind of tell that they believe the claimant and that they are trying to help the claimant, in every way, in the way they can. And they may be a little more reluctant to find jobs, or they may take the judge's question and give it an interpretation that's more favorable. I rarely see VEs that are just clearly hostile to a claimant. So if anything, a VE is probably going to be, and maybe the ones that have done vocational rehab that kind of understand how difficult it is when you've been deconditioned from work to get back in the workforce 2 or 3 or 4 years later. It can be a real problem, and I think some realize that. I had a hearing the other day where the judge asked a question. I thought I think it's a good case. The judge asked only one question. It was like 5% off task, or how many days of work could they miss, and that it would be 1 day every 3 months or something like that, which wasn't really work preclusive. My question to the VE, not in a hostile way, was, do not, or is it not true that semi-skilled jobs or even unskilled jobs have a probationary period? And during that probationary period, if it lasts 3 months, would even 1 day off missed be a problem? Would there be a higher standard in terms of being off task? And the VE says, well, yeah, probably so. And again, I did that just to kind of protect it for appeal. But yeah, I don't find that VEs are inherently hostile. I just think they're there to answer questions for the judge. I think the judges kind of know what the VEs are going to say. I have had over the years, I think twice in 30-something years, where a judge literally adjourned the hearing because the VE was so completely out to lunch. I mean, making no sense at all. I mean, it was just bizarre. And the judge is like, well, I think we need to adjourn this hearing, and, actually called me later and said, I had to do that because this VE it was a woman who was, unfortunately a little bit older, and I think was not mentally 100% there. And, the judge is just like, there's no point in going through this because, she's clearly not able to give testimony. But for the most part, I don't get the sense that VEs are there to hurt you. I just think they're there to give testimony. But I would agree with what we all have said, is that I don't spend a lot of time looking at the resume. I'll glance at it. If it's something that jumps out at me, okay. But I'm not going to, in my practice, I don't find going after VEs, based on their credentials or the numbers they come up with, has really ever done any good for me. But that's just been my experience. Okay. Let's see what else we got here. Okay. Peter Potensis says, thanks for all you do. You're welcome, Peter. My question, this is a good one because, and it's a little different because basically just his question is, how does a new Social Security lawyer start out? Meaning it takes most cases many years to hopefully win. How does a new lawyer like yourself stay afloat in the meantime at the beginning? And obviously, Sydney, you're working with Jeff, so it's not like you're starting out from Jump Street. My take on that is it is difficult, because if you are starting out and this is all you do, and I do, I have a couple of lawyers that I've mentored over the years that are starting out, it's hard because, you don't see any cash flow maybe for 2 years, and then it starts real slowly. The best advice I would give would be, you have to find something else to do while you're waiting for the cases to turn over. One thing that the people do, if they've got experience, they could do contract work. There are a lot of firms that will hire contract lawyers to do hearings. There's some non-attorney reps I know that hire contract lawyers. I've done some of those. There's some, insurance companies will hire contract reps, attorneys or non-attorney reps to do hearings. That's one way to do it. I know people who do brief writing. That's a way to do it, or they hire themselves out to do case development. Or the other thing is they, find other areas of law. I mean, I did bankruptcy work for years and years. And even though it's difficult because the fees are not real high, it's pretty quick. I mean, you do a Chapter 7, it's going to be $1,800, when you do a case. And so, if you have, 2 or 3 or 4 of those a month, you can at least keep the bills paid. But yeah, it's hard. Jeff, how would you answer that if you're talking to somebody who's brand new?
Yeah, that is a great question. And it is hard. There's no two ways about it. I personally was fortunate in the sense that I began practicing law in 2014, and I had a separate practice, different area of law. And then I transitioned into disability law in 2018. So I already had some funds lined up, and I recognize it's going to take a couple of years to really build a pipeline and see the fruits of the work that you do. And I would say, if there's a couple ways to go about kind of supporting yourself while you're just getting started. The first being, like Jonathan said, look to do some contract work for some other firms. There's a lot of firms that have overflow work where they need some help at the hearing level. So you can advertise yourself. You can contact some of these firms to ask if they do have any overflow work to get some of that hearing experience as well. You can also focus advertising on trying to find clients that are on appeals versus the initial, so you're a little closer to the end of the claim. And then other types of work that is perhaps non-disability related. But the nice part about being in practice for yourself is you do set your own schedule, so you can clear up time in your work week for other things you could be doing for gainful activity. So yeah.
Yep. No, I think it's and I think there's this perception all lawyers are rich and make all this money. It's like anything else. You got to build it up, and it's not easy. I mean, there's a lot of competition out there. A lot of people spending a ton of money on advertising. It's very hard to find a way to cut through the clutter. Now one thing you said, which you got to be careful about, is if you say, like, I'm going to take on doing some hearing work, you got to learn how to do it. I mean, it's, I remember my first hearing many, many years ago, I was scared to death. I didn't know what to expect. And, the one nice thing now is that they record all of the hearings. And so, if you find an attorney, and I think one of the things would be useful to do is, if you're starting out as an attorney or non-attorney rep for that matter, try to find a mentor, somebody who's done it, and ask them for advice. I mean, again, people call me and I'm happy to help them to the extent I have time. But one thing that I find is helpful is listen to some hearing recordings. Again, you got everybody's permission to do it, but if let's say somebody was to call me and say, I'm learning this area, I want to sort of know what I'm doing, I might ask a couple of my clients, do you mind if I share the audio? Some would say no, and some would say sure. And if I had 2 or 3 that were okay with it, and of course the person listening to it would have to sign a confidentiality and so forth, but assuming everybody's okay with it, listen to a few hearings and get a sense of what goes on. Even better, if you have somebody that's kind of your mentor, see if you can sit in on hearings. I did that. I remember I used to do that with live hearings. I would bring a new attorney with me. They would sit in the back and watch the hearing, and they just kind of get a sense of it. But at some point you got to do your first one. As a client, you don't necessarily want to be that person's first hearing, but I would say that what I would do is there are certain cases maybe that are a little more challenging that a lot of attorneys won't take. For example, SSI cases many attorneys don't want to take them because there's not a lot of fees in them. Maybe that would be a way to kind of get some experience. Take the case. If you're starting out, you're probably not going to make very much money. The client would have to be okay with it, that you let them know that you're kind of new at this, but you've done your due diligence, and get some experience doing it that way. I don't think this is a really hard area, because the law is the law. I mean, it's basically, you're trying to prove that somebody can't work. There are different theory, 3 theories of disability. They meet a listing, which usually they're not going to meet at a hearing. They meet a grid rule, or is their functional capacity so reduce their capacity to work, there's no jobs that exist. And you do your homework. It's just not especially difficult. It's just, you got to just sort of know how to proceed and how to ask questions. And again, getting a good mentor, somebody who can help you, is a good way to do that. But yeah, cash flow wise, it can be a challenge. There's no question about it. No question about it. All right, Sonia Stringfellow says, hello from Chicago. Hello, Sonia. Hope you're doing well. I've got Ron Kimbrough from Arlington, Texas. I assume it's somewhat warm in Arlington, Texas, because it's somewhat warm here. Sonia says, hello. I think she said Cindy. I think she means Sydney. But okay. We got hello from Puerto Rico, Juan Gonzalez. Hello from Puerto Rico. Baxter is one of my regulars. I have an intractable seizure disorder, medication resistance, and take 2 high-dosage anti-seizure meds. How much weight would that hold in an SSDI case? Okay, so seizure cases are a little bit of a challenge, because in my experience, there's really, unless that you wear some sort of a monitor, it's very hard to know objectively how often somebody has seizures. How do you guys approach seizure cases?
We also agree with that. We have had quite a number of seizure cases, and we've won a bunch, we've lost a bunch. Typically, the theory of the case is fairly straightforward. If you don't meet the listing for epilepsy or a seizure disorder, you're really arguing that these uncontrolled seizures are happening despite treatment with a neurologist and trying different medications. But because a person's having seizures beyond their control, they would have to take too many breaks from work. They'd be absent from work. They're also a liability at work. So the theories are there. It's a question of, is there enough evidence to really prove to the judge that the seizure disorder is real?
Yep.
And the vast majority of clients that we've seen with seizure disorders, they are legitimate seizures. But we've also had a couple of clients, few and far between, where it's more somatic. And the seizure activity, I mean, it's not showing up on EKG or EEGs. Yep. And occasionally clients will take videos or photographs and they'll send it to us. And we're not doctors, but when we look at some of the evidence that they're providing, we can tell it doesn't appear to be a seizure.
Yep.
So I'd say from my side, and I'd like to hear Sydney as well, but what I typically tell clients is, try your best to, if you have to take a few of these EEG tests, just to, hopefully 1 or 2 will show that there's some abnormal activity. Next best is to try to build a record with as many third-party statements, witnesses. Some of the best, secondary evidence are going to be observations from doctors. So a lot of times clients with seizures, they wind up going to the ER. And some of those doctors that initially, see the patient, they note in the progress notes some seizure activity. So we'll call that out. Sid, what else do you think that we do?
Yeah, so I think that you did name all of it. Some of the most important evidence is going to be that EEG, is anything showing up on it. But more often than not, we do find that those results come back normal. So like Jeff said, you need to supplement, get those witness statements in, have people talk about how they've seen your seizure affect you, talk about what happens. We also want to find out, what the severity of those seizures is. Are they biting their tongue? How long is it lasting? What is the recovery process like? Because if someone has a 1-minute seizure, but it takes them 3 hours to recover, they're going to be out of work. And additionally, we ask clients to document their seizures, whether that be by video in a seizure diary, and to make sure that they are reporting those to their doctors. That way, when the judge looks at the medical records, they can see how frequently that person is actually having a seizure.
Yeah, I think, Jeff, one of the things you said really resonates with me is the word seizure sometimes takes on a very broad definition. I mean, a seizure medically would be, where you lose control. I mean, you really have no control of, your either your body or your mind or whatever it may be. I've had people tell me, well, I have seizures, and it's, where they're staring straight ahead. But again, without evidence and objective evidence, and one of the themes that all of us really focus on is objective evidence. If you don't have objective evidence, it's really, really hard to win, because I think this is one of these conditions that people use the term a little fast and loose at times, and I think it can be judges can be a little cynical about it. Now, a second point though, and I think Baxter, you sort of talk about it, you're taking 2 high dosages of medications. That's actually pretty relevant to me, because, when a doctor prescribes high dosage of medication, that means the doctor accepts the fact that you're having seizures. And the medications to control seizures are pretty powerful, and they're going to have significant side effects. So you're taking 2 high dosage anti-seizure medications. That says to me that there's, something going on here that would work in your favor. But, you're also working against you is the reality that judges see a lot of people claiming seizures, just like they claim fibromyalgia, they claim fatigue. But, it's sort of this generalized term, let's call it a lowercase s with a seizure, but a seizure that is an epileptic seizure or neurologically based seizure is really what judges are looking for. And that's where, the high dosage medication would come into play.
And I would add one final point there too.
Yeah.
Just as you've seen as well, I'm sure, Jonathan, like certain cases, certain conditions, they tend to have a certain overall profile to them.
Mm-hmm.
And something that we've seen with, seizure disorder type cases is a lot of times our clients will have a lot of unsuccessful work attempts. They just have a difficult time sustaining work, but they keep trying because they keep having these seizure activities while at work. And that's generally why the job ends. So I tend to see that a lot with seizure cases, just a lot of short-lived jobs.
Yep. And that's actually good evidence as well. You just mentioned something that really brought something to mind in terms of, just approaching cases, and that was profile. And my experience has been that judges, when they see a case, and if I was a judge, I would do this too, a back pain case, there's a certain, in their mind, what they expect to see to pay a back pain case or neck pain case. If it's a cardiac case, they have certain expectations. So, part of what a rep can do for you is, if you try enough cases, you kind of know what these profiles look like. They may be informal, and every judge is going to be a little bit different, but, I know if I'm going to pursue a low back pain case, there better be an MRI in there, and it needs to show something. That's what judges expect. There needs to be, physical therapy and epidurals and maybe a surgical order. Those are the things that kind of meet that profile. And if you go in and you're saying, let's go back to the seizures, I have these seizures, but that it doesn't meet the profile the judge had in mind, that is going to be a problem. So, if you're pursuing disability, you're focused on what's going on in your life. What a representative does for you is to say, let's step back and look at your case in light of all the other cases I've handled, and are you meeting that profile? And if you're not, you're going to have a real uphill battle. And I will tell you, one of the things that I think is a really, really important, or 2 things that are really important, every case, your age is much easier to win when you're over 50, and even more so over 55. A 35-year-old is going to have a really tough time no matter what the condition is. And I think work experience is really important. I've had judges tell me that somebody comes in with 25 or 30 years of work experience, that means something. That person's credibility is going to be higher, even though the judge can't say that necessarily on the record. It makes a difference. So, having a sense of what it takes to win cases, just because you've done enough of them. For example, in a negative way, I have tried a number of fibromyalgia cases over the years. I have never won a fibro case for a male. Now, maybe that's just me, but I've never seen a male fibromyalgia patient win disability. I think judges expect it to be a female for whatever reason. My experience, maybe you had different experience, but just things like that. So if somebody reaches out to me and they're a man claiming fibromyalgia, probably not going to take that case because it's just, I've not had any success with it. Would you agree that these, I assume you have profiles in your mind when you're talking to people as far as whether this is a case that can be won or not?
Oh yeah, 100%. And in fact, I would echo that on the profile for fibromyalgia cases. I don't think we've ever had a client with fibromyalgia be approved. Sydney, correct me if I'm wrong.
You're wrong. There was one, and he was a male, but he also had severe back pain.
Okay. Now I've won a number of women, and I think generally my approach, my look at, and I don't want to get into a whole discussion about fibromyalgia, but when I find a lot of times it's very high achieving type A women who've achieved professional success at a level much higher than their education or training would otherwise allow for. They've kind of just, they've really been high achievers. And it's almost like it's almost like a mental shock reaction. It almost seems like that, they've been, playing the game so long and so hard and working at 100% so long that they just kind of burn out. That's kind of what I find. And a lot of my fibro clients are very organized. They'll come in with notebooks that are labeled and tabbed with all their medical appointments. They've gone from doctor to doctor. And, I have no doubt they are truly suffering, and judges sometimes will approve those cases. The problem with fibromyalgia is that it was so overused a number of years ago that many judges just kind of, they just kind of, put their hand on their heads when they see it because it's so overused. But a legitimate fibro case with a rheumatologist, support can be a winning case because it is very, very real. And, I've known people that have had it and it is devastating. You can't function. But again, proving it, how do you prove it? That's the real issue. That's the real issue. All right, Sydney, looks like somebody in your fan club is here. Sanjana is there. Okay. Big Ta. Okay. Big Ta received his brief yesterday from his federal appeals attorney. Do you know what kind of timeline I'm looking at from this point? So it would appear that Big Ta is at federal court. And by the way, so everybody knows, the disability process, you file your application, that's called the initial application, usually takes about 8 to 12 months to get a decision, depending on where you are. Could be a little less, could be a little more. If you lose there, which, 65%, 70% of people are not going to get approved at initial, you file what is called a reconsideration appeal, the first appeal, another 6, 7, 8, 10 months. You lose at recon, you file a request for an ALJ hearing, 7 or 8 months. You get the ALJ, doesn't see it your way, you're denied, you file an appeal to the appeals council. That could take 2 or 3 months. It could take a year. Just depends on their how busy they are. If you lose at the appeals council, you can then file a case and take a case to federal court. I personally don't do federal court work. I've done a little bit of it. It's a different enough practice for me that I don't do it. I refer it out. But it is many of the people that do it are, if they're citing case law, they've got to know the case in their particular circuit. It can take, I don't know, what do you find? A year, 8 months, a year to get a decision out of federal court?
Yeah, I'd agree with that. We've had probably about 10 to 12 federal remands over the last few years. And yeah, generally after an appeals council denies, and then Same thing as well. We don't handle federal appeals in-house. We have a couple of really sharp attorneys that we refer that work to. And it's nice because when they do, when they get the job done at the federal level and we get a remand, the client does return to our firm. And it's always nice to get another opportunity to get that claim approved. And I don't know how much truth there is to this, but it does feel like we're at more of an advantage when there is a federal remand. Perhaps there's more pressure on the judge. It depends, of course, on the underlying issue. If it's poor audio quality the first time, or if it's not really a non-factor, but still a technical reason that warrants a remand, it may not make a big difference in the overall claim. But more often than not, we've had pretty good success with the federal remand cases.
Yeah, that question comes up here sometimes is, if a judge, if you appeal a judge, an ALJ, and it goes to appeals council or federal court, then it gets remanded back. Number one, is the judge going to be upset that you appealed him or her? The second question is, do you have an advantage or not? My answer would be, I don't think that judges take it personally. We're representing our clients zealously, which is what we got to do. And it's not personal. It's just, we think the judge made a mistake. And quite frankly, the judges don't actually, they have decision writers. They don't really write the decisions anyway. So a lot of times the sloppiness is because of the decision writer more so than the judge. So the judges don't take it personally. And I would say that some judges, kind of read between the lines. If the appeals council is going to send it back, they're basically trying to send a message to the judge. Some of them don't get that. There's a couple of judges I know that don't care at all. They're going to, do what they're going to do. But I think you're probably right that many judges, if they see the case coming back from the federal court, they're sort of going to understand that there's a reason this case was sent back, that the federal court is sort of telling them, you need to give this case a really long look. So I would agree with that. Not every judge, though. It's going to depend. And that's another thing, that always bothered me about this practice area is, you have an any one hearing officer. I don't know if you see that out in Phoenix or not. I know, again, I do work nationally, but when I just did stuff, most of my work in Atlanta, you might have a judge. There was one judge here is 13% approval rate. The judge in the next office was 75. And that used to really tick me off that, it just depends on, it's a lottery. Why should it be a lottery? I mean, shouldn't there be some sort of a standard? Because nationally it's about 50% of cases going to hearings are either fully or partially approved. But I mean, that used to just bother the heck out of me. It still does, but what are you going to do? But that is a problem. I don't know if there's any fix to it, but you get the wrong judge, you're just not going to win.
Yeah. It does seem like some judges, they look for reasons to approve the claims that they feel are deserving. And then there's some judges, for whatever the reason is, they look for reasons to deny.
Yep. Yeah.
Like do
you tell your clients to look at the judges? I mean, there's statistics out there, there's websites. Do you discuss that with your clients? Do you talk about, this judge has got a 43% approval rate, or this one's got a 55 or 27? Do you even mention that, or do you just sort of say, let's just take it as it comes and we'll deal with it when we get to the hearing?
Personally, if a judge is a stronger approving judge, I usually just tell a client, you've been assigned to a good judge. If it's one of the poorer judges that, say, has a less than 40% approval, I'll actually tell them the approval, just to perhaps manage some client expectations. But my usual spiel in talking about judges is the poorer the judge, the more mistakes they tend to make, and the hearing is not the end of the road. There is a final recourse with the appeals council and even with the federals. So that's usually what I tell clients. Yeah.
Well, I find and I think you mentioned 40%. That's kind of my rule of thumb too. I think, again, if the average is 49 or 50%, the last waterfall chart showed that, any judge in the 40 to 50%, or 40 to, let's say, 40 to even 55%, is probably pretty reasonable. I mean, not every case is a great case. And it also depends on how many hearings the judge has heard. If it's 15 cases, that's not going to really be accurate. It's going to tell you very much. You get below 40, that's starting to become a little troublesome, because that's pretty far off the standard. And I just, that does, and, and again, I tell my clients, look, you got a tough draw. Doesn't mean we can't win. It's just, we're going to have to really, make our case very, very strong. But I would agree with you. The lower approval judges tend to be mistakes in the decisions that you can exploit. And again, nobody wants to have to go to appeal, but if you got to do it, you got to do it. Sonia Stringfellow says hello to you as well. Mary Simmons, hello, Mary Simmons. Hope you're doing well. Michelle says, just passed the EDPNA. Thank you and congratulations, Michelle. I can do it on paper. I'm not sure what that means, Michelle. Maybe you could clarify. But congratulations on passing it, and good luck with taking on cases. Pre-hearing tips. Yeah, I mean, I think that, everybody, I can tell you, and I do, and I think it's important to know, just so you won't be freaked out about the process, what the judge is going to say. The judge is going to welcome you and ask you to verify your identity, and ask for your birth date, your address, and your last 4 digits of your social, and ask you, are you recording the hearing, and you're okay with the telephone hearing, and are you by yourself? Yeah, all that stuff. I can give you a piece of paper that shows that. I do think that you have to have the right mindset, and even again, judges are human beings, and they are also under pressure because the Social Security Trust Fund is running out of money, and there is pressure that not to approve cases that are not deserving cases. And there have been instances where judges are brought in front of subcommittees in the Congress, and they are just cross-examined like nobody's business. There was one judge, and I've got the video someplace. There was a former, I think he's South Carolina Congressperson, Trey Gowdy, and he was a former prosecutor, kind of a, just buzz cut kind of guy, just really hardline prosecutor type. And he gets this judge, and I'd been in front of this judge before, and the judge had a 99% approval rate. And Trey Gowdy, who's no longer in the Congress, he's like a radio commentator now or something, but he just ripped this guy, backwards and forwards. And how can you possibly approve 99%? It was painful to watch. It was just really, and like I said, this judge was a nice guy. He shouldn't have been approving 99%. In the case he approved for me, he didn't do anything. I mean, he really literally just said to the client, so you feel like you're disabled, right? Yes. Okay. And then we spent the next 20 minutes talking about restaurants to go to in Atlanta. But I don't think that any judge wants to be in that situation where they're questioned about what they did. So yeah, they're very aware that Congress believes that there's too many approvals and that they're running out of money, and so they are going to make sure that you prove your case. And I think, like I said, some judges just have the feeling like, I'm looking for a reason to turn you down, as opposed to the other way around. Okay. Hello. Would you mind? I would not mind. No, you are one of many. You are one of 68 people. Would you mind right now here? Okay. Should I expect CEs during reconsideration? Jaime Guerrera says. And what Jaime's asking is, a CE is a consultative evaluation where the adjudicator, basically, when you file your application, the case is assigned to a division of your state, typically called DDS or DAS, and they have claims specialists or adjudicators who are basically adjusting the file like a claims adjuster. And they have the certainly at the initial, it's very common, but at recon as well, they can send you out for a consultative evaluation. Do you see many at recon, or is it mostly at initial?
I think we tend to see more at initial.
Yeah.
And then if there wasn't any at initial and it's a denial, then we'll sometimes see them at recon. But I think just general sense would be 2/3 at the initial, maybe 1/4 at recon, and occasionally we'll get to the hearing and there have been no CEs scheduled. So
yeah, occasional. Well, I find that sometimes the recon adjudicator will send the person back to the same doctor for a second, especially for a psychological evaluation, for a second one. Has anything really changed? And so that's not that uncommon. But I would agree. I would probably say, in my experience, it's probably maybe even only probably 25% recon, 75% initial. But it is within their purview to do it. This actually came up with one of my clients. They were quite upset. Why did they schedule me for a mental health consultative, a psychological consultative? There's nothing wrong with me mentally. How do you answer that?
There's not an easy answer for that. But I find if they're going to schedule a psych CE, it must have been brought up in some capacity, some level of depression or anxiety. It's just one of those trigger words where if it shows up even a little bit, I think a lot of examiners are trained to just simply go ahead and schedule it for a psych CE, and they're just covering their bases in doing so. It may not be a primary disabling condition. It may not be a severe impairment even. But a lot of times, if the condition is rooted in a physical medical condition, a lot of clients wind up developing that depression or anxiety. Yeah. It's just a byproduct of seeing the limitations that they have and not being able to do the things that they once were able to do. So.
Or being in chronic pain or not working and having no money coming in. Yeah, it's and just, I have a lot of people say to me, my job was my identity and I'm not able to work. And I'm like, I don't have any purpose in life. So that can be depressing. Medications, again, being in chronic pain, family pressure. I mean, I'm sure you guys have seen it as well. I've had a number of clients, go through divorces because they're not bringing money in, and their spouse becomes very disenchanted with there's no money, they're not in a good mood, they can't really help out around the house. It's so. And I would also say my experience, and again, I'd be curious to see if yours is the same. The psychological consultatives often will provide some value in terms of evidence that I can use. It may not eliminate every job, but it can eliminate maybe skilled jobs or semi-skilled jobs because of focus and concentration or emotional stability. I don't get as much benefit out of the physical consultatives, but the psych consultatives, I think, many times, not always, but many times can give me benefit. Is that your experience as well?
Oh, sure. Yeah, absolutely. Sometimes it could just be social interaction. Claimant can attend a psych CE and be in a bad mood or have poor eye contact and give a little attitude to the examiner. And there's something mentioned in the social interaction domain. And now we're looking at occasional interaction with the general public and coworkers and supervisors. So more often than not, it's those psych CEs don't necessarily support a listing level argument, but it can be used to erode the job basis to some degree.
And that's really a lot of what you want to do is you got to just chip away. I mean, if you just imagine, there's, I don't know how many thousands of jobs in the DOT, but you can chip away. So like, for example, if you had seizure issues, even if it's not enough to win the case, it may eliminate, you may not have a driver's license. So jobs that involve driving would be eliminated. Jobs involving a forklift would be eliminated. Jobs working on hazardous equipment or moving mechanical, moving machinery would be eliminated. Then you may have something else that eliminates other jobs. Just chip away at the job base is really what you want to do to the point where there are no jobs. And again, ultimately, a lot of cases turn on the off-task question or the missed time from work question. But yeah, that's what you're trying to do here. All right. Mike Ramirez says hello from Arizona. That's your neck of the woods.
Hello, Mike.
All right. And Would You Mind is in San Diego. Very nice place. Been there. Bala, who's one of my clients. I just checked to see. It still says post-hearing review. We're going to win. I know you're anxious and we want to get that in, but it's still in post-hearing review, which means I think that they don't have space at the decision writer's office yet, but we'll get a positive result there. What if? Well, that's a very open-ended question, so I don't know how to answer that, but okay. What if? Patrick O'Malley. I am in the reconsideration phase and received a phone call to call the Morrow, Georgia office. I spoke to Mr. Strickland. Then I received a phone call from Georgia DDS. Both calls came on 7/7. Well, I'm not sure what date is, but maybe the question here is it typical to get calls from the DDS? Oh, wait, there's the rest of it here. Just happened to check it. Knows my case is now with the SSF medical closed out final review. Is that a good sign? Okay, so basically Patrick got some phone calls from Social Security, and online it says that it's in final review. Is there anything we can tell him that this means, or is it simply we don't know because this is all procedural? Is there anything this tells you?
Well, a lot of times I would say if it's a non-medical review and DDS or the field office is calling, it likely means they might be missing a piece of information about perhaps past work or work activity, or maybe a workers' comp component, or just something that's not part of the medical review, but there's a question mark there that's needed to fill a gap. I don't think you can read too much into it one way or the other if it's a good or not.
Yeah, I would agree. I think that, they're calling you, there may be something specific they want, but that doesn't mean you've won or you've lost. It's gone. What actually is happening is the adjudicator or the claims specialist is gathering up medical information. They send it to a doctor who works for them kind of on contract to look at the file and to help make a decision about whether this is significant enough to erode, make them erode the work the base. There's no jobs out there. The adjudicator makes the final decision on that. Where it is in the process just means that it's getting close to the end of that process. It doesn't mean positive, it doesn't mean negative. It just means that your case is getting close to having a decision made, is what I would say. Chloe says, good evening. Hello, Chloe. Okay, this is an interesting one. 52 Kimmy. Sydney, I'll throw this one to you. How does a suicide attempt affect your case, especially if you end up on ICU and stay in the hospital for a month?
Yeah, so that is extremely helpful for a case because that would support the off-task or absenteeism argument. If you're going to be in the hospital for 30 days, you're going to be out of work. And the more hospitalizations that are in the record, the better chance you have of getting approved. So I'm so sorry if you know anyone or if it was you, but it will be helpful for your case.
Yeah, I would say, I would take it as, I would say, I agree with what you said. I would also say that when I'm looking at mental health cases, again, just like back and neck pain, very common. Mental health cases, there's a lot of people out there with depression. And as Jeff said, part of it's because, you're in chronic pain, you're not working, external factors. Judges see depression, people are taking, antidepressants or maybe seeing a psychologist or psychiatrist. It's very common. Anxiety, PTSD, it's unfortunately very common in our world. So what separates a really strong mental health case from one that's maybe a factor, but not enough to push over the finish line? I look for things like inpatient hospitalizations, suicide attempts, multiple failed medication trials, extensive ongoing treatment with psychologists. Again, the medication, they've tried multiple different medications, nothing really works. But a suicide attempt is, evidence of a pretty significant problem. Now, my opinion would be, a one-time suicide attempt 4 years ago is probably not going to make as much of a difference. But I think that if it's more than one, they're fairly recent, and it seems to be kind of an ongoing problem, suicide ideation or suicide attempts, that can signal a pretty significant mental health issue. Jeff, would you agree?
Yeah, definitely agree with that.
Yeah. It's those are hard mental health cases. And I'll just ask both of you, what do you look? That's what I look for, is sort of I call them indicia of severity. That's the sort of thing you guys look for as well? What makes a really strong mental health case in your mind? And what kind of evidence do you need?
Yeah. Sid, you want to field this first?
Yeah, so I think just to start with, talking about hospitalizations, that is extremely supportive evidence for any type of mental health case. And additionally, you want to make sure that they are seeing a psychiatrist. That's important to show that they are being prescribed different medications. Like you said, Jonathan, talking about a different list of medications. What have they tried? Are they resistant? Is it not helping? And also seeing a therapist or psychologist, those records are really good because they're different than psychiatrist records. A lot of times when you see the psychiatrist, they're in there for 5 minutes and it's a very short note. So when they are seeing a therapist or a psychologist frequently, those can be really great records.
Yeah,
I agree with that.
Jeff,
and then
what's your take?
just to add on that, I think the psych-related disability cases are very challenging to get approved, and I find that the strongest medical evidence is going to be a persuasive medical opinion.
Mm-hmm.
And as a judge, they're looking at different factors to weigh the persuasiveness of a medical opinion. So I'm looking to, if a client contacts us, potential client contacts us, I look to see, do you already have a good relationship with a therapist? Have you been in treatment for some time? If somebody's looking to apply for disability for the first time and they're not currently in treatment, I usually encourage that client to get the process started on their own, get into treatment as soon as you can, and then if you're denied, which, we know there's a high probability that's going to be the case, especially for psych-related cases, contact our firm and we can help on appeal. But I do look to make sure look to see if there's already an existing relationship with that provider, and do we feel as though there's a great chance to get a medical source statement completed from that provider.
What is your take on VA, Veterans Administration psych treatment?
Yeah, that's a whole different ball of twine right there. Those VA providers, they're very sticky. They always stand behind I think it's a fictitious policy that they don't complete these disability forms. We actually have a customized request that we send to VA providers pointing to a regulation that says that's bogus. You can complete forms. And a lot of times we do have to suggest to clients to, veteran clients to look for treatment outside of the VA system because of the value of those medical opinions. When you go to a psych, evaluation, it's a 60, 90-minute evaluation. And they, as you know, they administer a very surfacey mini mental status exam. Can you remember 3 words? Can you do serial 7s? These are very basic questions. And they're very oftentimes judges will use a score of a 27 out of 30, a 29 out of 30 as a basis to show that it's just certain areas are not that severe. But that's far from the truth. Just like the physical CEs and the little tests they do for hand functioning. Can you lift up little coins or twist a bolt or a nut around a bolt? I mean, very basic. So it's super important to get some treating source statements, especially for the psych cases.
Yeah, I find with the VA, VA records tend to be voluminous. Hundreds and hundreds of pages with a lot of duplication in it. Second is a lot of the psychological treatment is group therapy, which is less valuable in my opinion because it's not going to really talk about the individual person as much as what the group is doing. They tend to overprescribe meds. You have people that are just on, 15 different types of medications. You really kind of wonder, is this really appropriate treatment? And a lot of times they limit them as far as how long they can get treatment for. So I completely agree. I think that if you're giving treatment for psychological issues at the VA, it's probably worth trying to get treatment outside the VA if you're going to pursue social security disability. I just think that's unfortunate, but it is. Not always, but it is a lot of the times.
Yeah.
All right. So Wonderful says, is it normal to apply for disability and they give you SSI? I'm guessing what happened here was they approved you, but they changed the onset date to after your date last insured, or you applied for disability, you were not insured. Is that how you would assume this is what happened to this this young lady?
I mean, if you're applying for disability, there's either SSDI or SSI. So maybe it was a concurrent claim file, but like you said, they didn't have an insured status when they medically became disabled. We've also have clients that simply refer to early retirement as SSI. So, and sometimes they file at age 62 for disability, and then they receive their early retirement, and they call it SSI. And to add some confusion even to reps, when you look at a claim file at a hearing and there's early retirement, they'll call that a notice of award.
Yeah, I've had that. That's exactly. I've had that happen to me. We get this notice. My staff will get a notice of award. They approved the case. Like, no. They approved the early retirement, not the disability part of it. So
yeah, big whoop.
yeah. But yeah, I mean, and that's actually, you raised another point, and that is a lot of people think when they say Social Security disability, they call it SSI. It's like calling the tissues you have in your bathroom Kleenex, or the copy machine a Xerox. SSI is a type of disability, but it is not a generic term. And it means something very specific, and that is supplemental security income, which you would get if you don't have the credits for disability. And I suppose the other thing that could have happened to Wonderful here is when she applied, she may have said, well, I want to apply for SSI, and didn't actually apply for disability. I've seen that happen a couple of times. So, you might want to check to make sure that they actually considered a Title II SSDI application in addition to your SSI application, if in fact you were insured. So, can't really answer your question without knowing more, but that would be my thought on that. Do I answer questions? Yeah, we are answering questions. Would you mind? Okay. I think we've already talked about Patrick's case. Absolutely, Patrick. So I think that our conclusion, I think in the three of us, would be that the notices you're getting seem to be more procedural in nature, and there's nothing we can really draw out of that in terms of whether that's positive or negative news. Procedural, I think, is what it is. All right. Haq Assad asks, if granted, how do written VE interrogatories usually work? And so I think what he's asking would be, can he pose written interrogatories to the VE? And I guess the judge would have to approve that. I've seen that happen a couple of times by judges where they'll ask the VE a series of questions. My understanding, I could be wrong, is that that's something a judge would have to agree to. And I don't know that a judge would agree to it before the hearing. I think that, you could certainly, again, if you take this approach, you could, decide to pursue, or in fact, if you're going to do this, I would let the judge know, that you're going to challenge the VE's qualifications or methodology. And, if the judge does not wish to spend the time at the hearing, I would like to pose, interrogatories, but it's not very typical. That's my answer to that. Would you agree?
Yeah, I agree with that. There have been a couple of cases where judges after a hearing will send out interrogatories to the vocational expert and then provide our firm with an opportunity to respond to that or ask questions of our own via interrogatories. The only other thing I can think of along the lines of Hakasad's question is there are a few cases I can recall where I knew it was going to be a step 4 case, and we have consulted with other vocational experts where we've produced as evidence a report, and I would ask interrogatories to a VE that's obviously not testifying at the case, just want a vocational expert that's their profession, just to introduce new evidence into there to perhaps refute potential testimony.
Yeah. I've done that once or twice. I've got a case right now where we, submitted a report from a separate VE, because as it is an appeal matter, because we felt that the VE was just really was kind of out to lunch. Jeff Brown says, good evening, Jeff Brown. We have Masanja Washington, hi from beautiful Michigan. Hello. Okay, so Patrick says, does this mean a medical decision? Patrick was the one who's asking about, he said closed in his portal. Again, our feeling is that what you're seeing there is procedural. A decision appears to have been made. You'll know, hopefully good news in the next week or two, but because it says a decision's been made doesn't mean it's a good decision or a bad decision, just means it's a decision. So, okay. KU Thunder. Good evening, Jonathan, Jeffrey, and Sydney. Good evening, KU Thunder. Chloe asks, many applicants focus on proving they can't do their old job. The VE is often talking about other jobs. And what's the biggest misunderstanding people have about how vocational experts decide what work someone can still do? So sort of a two-part question. First part is, and Jeff has referred to step 4, which is the can they return to past work? Social Security uses something called a 5-step sequential evaluation process. Step 1 is, are you working at SGA level? Assuming you're not working. Step 2 is, do you have a severe impairment? Severe basically is, do you have something that could potentially prevent you from working, being treated, that there's some diagnosis? Pretty minimal, but cases do get denied at step 2. Step 3, do you meet a listing? If you have life-limiting condition, you might meet a listing, but most people don't. Step 4 is, can you return to your past relevant work? Step 5 is, can you do any other work? And at step 5, what they call the burden of proof changes from the agency, from us, the claimant, to the agency. So one of the things we have to get through is at step 4 that they cannot return to past work. And the question Chloe's asking is, do people they misunderstand that just because you can't do your past work, that doesn't mean you're disabled. Do you have this, do people in your practice, this is something that people misunderstand? Do you have to educate about?
I think so. Some clients, they've gone through the short and long-term disability, which is really more of a focus on, can you do that job? Can you do your last job? And as we know, with Social Security disability, it is about other work as well. Other work does shrink as an individual hits age 50 and then age 55. So under 50, I tell clients we're up against the world of jobs.
Yep.
It doesn't matter really so much what you did in the past. We have to show you can't do any work whatsoever full time. But as a claimant gets older, if a client's above 55, oftentimes it is more of a focus that you can't do your past work, because that generally will eliminate other work. So that really depends on, I would say, age is the biggest factor on what the focal point ought to be.
Yeah, but I would say, for those who are applying for disability, realize that yes, past work is relevant, but you need to really think about it in terms of, could you do anything? Now, again, if you're over 55, maybe the grid rules aren't going to make you go that far. But I think in terms of your mindset, I've had people say to me, well, I've been a bus driver my entire life, or I've been a truck driver, or I've been a warehouse, forklift driver. I don't know anything else. I couldn't work in an office, or there are no jobs near me that would be unskilled jobs, or I don't have a car. That doesn't matter. It's if you had if one of these jobs came available, even if there are no jobs near you, could you do it? And again, if you're under 50, you've got to prove, and I give the example, imagine a job where you're sitting at a table putting ink pens in a box. I mean, it's a warm body, can you fog a mirror job? I used to have a video I'd put on here where there was a guy watching plush toys coming down an assembly line. And if you saw one that the stitching was off, he would knock it off the line. I mean, literally, you can fog a mirror, you can do this job. But that's part of that, that mental state or that attitude you've got to have is, this is not about just, could you go back to being a structural engineer? Or this is not about, could you afford to work a minimum wage job? You may be a, you may be a nuclear physicist, working at a technical university, making, 6 figures. But, if you are 43 years old, you got to prove you couldn't be a greeter at Walmart. And you're saying, well, I would never do that. Well, yeah, that's what they're saying. That's how you have to approach it. This is about work capacity, definitely work capacity. All right. What's the biggest misunderstanding people have about how vocational experts decide what work someone can do? Sydney, what do you think? What do you think the people misunderstand about how vocational witnesses do their analysis, maybe? Because they hear this, you're in this hearing and they got this person they'd never heard of before talking about, that they can do this job. What do you think? What do you think the biggest misunderstandings are?
Yeah, so I think for a lot of people, something they don't understand is we not only have to show that they cannot do their past work as it was actually performed, but we also have to show that they can't do it as it's generally performed. So that vocational witness, here's an example of a story that recently happened. We had someone that was an HR person, and she was walking for 6 to 8 hours during her shift. She was required to lift up to 20 pounds. And she thought, well, if the judge finds that I can do if she finds I cannot do my past work, then I'll be approved. However, the judge is going to consider how the job is generally performed. So how does an HR person usually do this job? It's usually a sit-down job.
Mm-hmm.
And because of that, she was denied. So that's one thing is people need to understand they're looking at how you actually performed your job and how it's defined in that dictionary of occupational titles. Another thing is I don't think people understand all of the jargon that they're hearing, those DOT codes. They're wondering, where is the judge coming up with this hypothetical? So the judge is going to come up with a list of restrictions for an individual. For example, they might say that the person can stand and walk for 4 hours, would be off task 10% of the time, and can frequently handle, finger, or feel. They don't understand where they're getting that information from. And generally, that information is coming from the consultative exam reports or any medical opinions in the file.
Yeah, and I think that, and I would also say this, that judges many times, let's say you testify that you can only stand for 2 hours, and the judge may put a 4-hour standing, or that you cannot, balance, or you can't climb stairs, let's say. The judge will say the person can occasionally climb stairs. They are doing this to kind of draw lines. Again, part of it's going to be because it may come from the consultative report, or part of it is because the judge wants to signal to the next level up, I gave this person the benefit of the doubt. I'm assuming they could do more than they could really do, but they're still being found, disabled or whatever, or I'm not finding them believable in what they're doing. So yeah, it's ultimately the hypothetical question is going to dictate what the vocational witness is going to say. So a vocational witness is not deciding on the work that you can do, after looking solely at you and interviewing you. They've never met you before. They're relying on the judge to give limitations. So if the judge says, standing and walking 4 hours, you're saying to yourself, I can only stand and walk for 45 minutes. But the vocational witness is going to give jobs that allow for 4 hours standing because that's what the judge told the vocational witness to do. So we're kind of at the mercy of the question the judge asked. Now, we as representatives can ask the vocational witness whatever question we want. I could say to the vocational witness, well, instead of 4 hours, let's assume person can only stand and walk for 1 hour. Well, the vocational witness will say, in that case, there's, the jobs identified are no longer available. But unfortunately, when the judge drafts the decision, they may use the hypothetical that was a little more expansive to make that decision. The hypothetical questions are, in fact, the judge's conclusion about your what is called RFC, residual functional capacity. Residual means left over. So what is your capacity that is left over? It's residual after we take into account your limitation. So the judge is the one deciding on those limitations. And you may disagree with it, and you may think the medical says otherwise, but if the judge is, used reasonable analysis to come up with those limitations, that's probably going to fail an appeal as well. So, again, this is why it's important to have the right approach when you go into it, have, as I think Jeff or Sydney said, a strong medical source statement so that you give the judge a very little wiggle room to identify functionality that is really not there. So that is a, kind of a primer about how vocational witnesses do, but they're not talking about you in a vacuum. They're doing it in the context of a question the judge has already asked. Do I answer questions from the chat room? I'm sorry, would you mind? But that's what we've been doing this whole time. So I'm not sure why you're not getting you're asking me you're saying, do you answer questions? Post your question. I don't really understand what you're asking me here, because you just asked me questions and I'm telling you, yes, we are. That's what we're doing here. That's what this is all about. Shanna Coates, I've had a mental exam on the 13th. What comes next? Applying to cervical and lumbar nerve root compression and vertebra and disc with bulges and herniations. Well, the first question I would ask you, Shanna, is your age, because if you are over 50, then the grid rules might be implicated here. And if you've got nerve root compression, that's most likely going to limit you to, no more than light work, probably sedentary. And you've got, vertebra and disc, I think you mean desiccation as opposed to dissemination, with bulges and herniation. And again, there's two different things. Bulges and herniations are different things. Nerve root compression is pretty significant. If you're over 55 and you've got nerve root compression, you're probably going to be limited to light or less. And assuming no transferable skills, you have a grid rule argument. If you're 50 to 55, you'd have to be limited to sedentary. So, they may send you out for a physical consultative evaluation, or ideally, if you can get your orthopedic doctor or pain medicine doctor to complete a functional capacity form or medical source statement or narrative report, that would go a long way to making your case stronger. Would that be the way you'd look at this as well, Jeff?
Yeah, I think, when you have cases that have physical and mental components to it, I'm always, really looking at the physical first.
Yeah, I agree.
More objective evidence. Judges are more inclined to approve cases that have a strong physical component to it. If we can get a client or claimant down to a sedentary functional capacity, that limits a lot of jobs at step 5. And then if there is a mental component to it as well, and we're looking at this small class of jobs that are considered sedentary and unskilled, oftentimes that, there's just not enough job numbers in the national economy for the commissioner, for SSA to meet its burden at step 5. So,
yeah. And again, I sound like a broken record. Social Security disability is about vocational capacity. You don't win with a diagnosis. You could have a herniated disc with nerve root compression, but if it doesn't stop you from working and doesn't create specific limitations on your ability to function, you're not going to win. So again, you don't win because you've got congestive heart failure. You don't win because you've got type 1 diabetes. You don't win because you've got, chronic kidney disease. You win because those conditions produce activity limitations that limit your functioning. That's how you win. Okay. Chloe says there have been growing criticism that some occupations identified by vocational witnesses are outdated. Have you noticed as judges becoming more skeptical with these job numbers? And where do you think that issue is headed? Well, my first answer would be that there have been a number of what they call emergency messages issued by Social Security, where they basically tell vocational witnesses, do not cite these jobs. Surveillance system monitor was one of them. There's a couple others I can't remember off the top of my head, but there's a number of jobs that are perceived to be, outdated. A microfiche operator, they're just, typewriter repair person. I mean, there's just certain jobs that just don't exist anymore. There are other jobs. I mean, that what they do is, like, for example, there's a telegraph operator job. I remember that's come up a couple of times, and the vocational witness will say, well, it doesn't exist as a telegraph operator, but the equivalent is, something else. And I don't remember what they use. So yeah, you got to be alert to that. I think that, every once in a while, Social Security will come out with a list of jobs they've deemed obsolete. Every once in a while, I'll have a vocational witness cite one of those obsolete jobs. And I have kind of a list of them kind of on a little, notepad. And so I just keep it open. And if they come up with that, I'll, ask them, well, are you not aware the commissioner declared this as obsolete? Then come up with another one is what they'll do. But, so that's probably not going to go very far. Or you could choose to remain silent and then attack it on appeal. I don't know. For the most part, I'm just going to say that's that's sort of ridiculous. And that does kind of suggest the vocational witness is not up to date with things. But they're going to continue to have that problem. Look, I think that Social Security has been looking for years for a replacement to the DOT because they know it's outdated. But they've spent untold millions of dollars trying to find other systems. And there was what was the one they were using for a little while? I forget. There's another system similar to the DOT. Now they came up with a ruling. In fact, any hearing you go to, the judge will ask the vocational witness, "What are your sources?" And they'll say the DOT and the selected characteristics of jobs or Job Browser Pro, whatever. And they have to ask them because this ruling says that if they don't identify their sources and they're only using the DOT, that by definition would be appealable. So they do this as I forget the ruling was SSR or something 14. I forget which one it was, but they all ask that question. But I think to answer Chloe's question, there are jobs that are obsolete. If you sense that a job doesn't make sense to you, you can certainly ask the vocational witness, have you ever placed a person in this job? Is this job, does it really exist in significant numbers? Where do you come up with those numbers? Again, you could do a little, kind of mild cross-examination, but I think that, Social Security, they know they have a problem with the DOT. They've come up with enough ways to cover so that the cases are not wholesale remanded and every decision is reversed. That's my take.
Yeah, a couple points that come to my mind. When I first started practicing disability law, this was there was the past relevant work period was 15 years. So we had a lot more jobs to go through at step 4. And in I think it was 2024, we got the SSR 243P. This was the Social Security's attempt to basically recognize that the DOT is way outdated, and they recognize it. So what they did was they reduced that past relevant work period from 15 years to 5 years,
which is helpful. Yeah.
Very helpful. And it just overall makes the process a little smoother. That's a lot of information that field offices have to collect for 15 years of work history. Reducing that to 5 just saves a lot of time from that portion. But the same regulation also really empowered vocational experts. The regulation allows vocational experts to supplement the archaic DOT with their own experience. So that's where judges will ask additional questions of a job expert about where are you getting your numbers from, where are you getting your testimony from. And if the VE says it's based on my own experience, a judge will likely accept that. And when it relates to some of these outdated jobs, I think the VEs they're still using those jobs that are from that emergency message, but they're adding something to it, explaining how it's performed in modern times. The surveillance, monitoring job, or the microfiche and pari-mutuel ticket checker. I mean, VEs will have the VEs will come up with how the job is modified over the years. But
Because it basically, I'm looking at the emergency message, and for those who are interested, you can look up emergency message 24026, which lists 114 jobs that cannot be used anymore unless the VE can come up with exceptions. So it always says the VE can say, yes, this job really does exist. There's a second one that's scrutinized, and a heightened evidentiary requirement is emergency message 24027. So examples of jobs in 24026, what's interesting, astronomer, you think that would be a geographer, it's just interesting here. Historian, I don't know, some of these, radio telegraph operator, okay, there's not any telegraphs anymore. Wire transfer clerk, okay, I mean, they're typically done in banks now. Telegraph agent, okay. Pay station attendant, things like that. So they're just, some of these fur farmer, I mean, there's a whole bunch of them in here that you would think they still exist. I mean, animal breeder, canary breeder. I mean, there's a lot of canary breeders here in Georgia. I don't know why they would take that one out. But yeah, some of these they just feel like there's just, not enough of these jobs out there. They've been mechanized. And I suspect with AI, we're going to see a lot more of that. So anyway, but yeah, it's kind of interesting that they've come up with all these jobs. But if you want to look them up, that's where they are. All right, Kathy Clayton says, good evening, Kathy. How does the ALJ decide if you've got transferable skills? Age 62, 38 years at one company, worked at an insurance company, changing updated medical benefits. Well, I'll give you two answers to that. One is that at age 60, there is a regulation. They call it a POMS regulation, and I'll give you that POMS regulation specifically. It is POMS, POMS, which stands for Program Operations Manual, DI 25015-017, 25015-017, that says that if you're limited to light work or sedentary work at age 60, there is a heightened standard. There's an assumption that there needs to be a minimal vocational adjustment to transfer any skills. So at age 60, if you're limited to light, or age 55, if you're limited to sedentary, there's a minimal vocational adjustment standard, which basically means that they've got to be able to prove that you could walk into another job that's so similar to what you did that you could just sit down and start doing it. Obviously, if you couldn't do your past job for some reason, then you're probably not going to be able to do that. That gives you a real benefit. So at age 60, assuming you're limited to light work, you're probably in pretty good shape there. Otherwise, the vocational witness will identify what skills you may have obtained, and they could be, skills are not traits. Skills are things like ability to type, or ability to, answer phones, or ability to, process spreadsheets or things like that. So the vocational witness would do it. That's my answer, is that the ALJ is not making it up. It's coming from a vocational witness testimony.
Agreed.
Okay. All right, Michelle, who's the new ED, is there, Sydney, is there like what do you call it? Is there like a word for it, EDP? I'm spelling out EDP and A. What is the title for an ED? Just a non-attorney rep, or is it?
Yeah, that's exactly right. You just say non-attorney rep.
Okay. It's not like EDPNA or something like that. I don't know.
No.
Social Security is known for all of their acronyms, DLI and, AOD and POD and SSDI and Title II. It's like a different language. I think somebody said this before. It's like a different language. So I just assumed there'd be another acronym, but I guess not. Okay. Michelle, who's the non-attorney rep, do you take clients who are all mental health? I will if the treatment history is there and they're compliant, but some reps will not take mental health cases or child cases. I'll give you my answer, then we'll see what Jeff and Sydney say. I will if the evidence is really compelling. Again, the indicia of severity, long treatment history, the suicide attempts, inpatient hospitalizations, failed treatment, things like that. But if it's not a level of severity like that, I'm going to be real reluctant, because those are just really, really hard cases. Child cases, I used to do them. I don't do them anymore, for two reasons. One is that usually, well, they're all SSI. And so there are a lot of times there's going to be offsets for household income. And there's usually going to be, means that the past due benefits are going to be greatly reduced. And it ends up being such a small fee that I'm losing money on the case. So that's one reason. The second reason is I did a lot of them for years, and I just saw too many cases where a family or mom would bring in the kid, and, the kid's got ADHD or ADD, whatever, and this poor kid would get labeled. And it's just, I remember I had a judge who was a very high approval judge say to me, he said, he goes, I think it's a shame that these kids are going to get labeled as disabled. It's going to follow them the rest of their life. He goes, I'm looking at, he talked to me about he goes, your client, this is not in the client's hearing, because your client's child is just poorly behaved, wasn't not properly disciplined. There's nothing wrong with him. He's getting B's in school. Doesn't have ADHD. It's just he was never socialized. So that kind of stuck with me. And I just, I realized there are people with have ADHD that is truly disabling. And there's certainly child cases where somebody has a terrible disease. I just tend not to take them. That's just my way. So I don't know. What do you guys do? Do you take them or how do you
from with the child cases, we've represented a few cases over the years, but we generally do not take pure child disability cases for some very similar reasons that you pointed out. And a lot of times I personally question, is this truly a disability, or is this is it parenting considerations at play? And as far as on the mental health side, I think that there are categories of, based on the type of medical condition there is. For example, if it's a PTSD, we get a lot of clients that are veterans and that they've served and they've had deployments. Oftentimes we'll take those cases because we know through experience that profile is going to result in some real strong testimony. And I'd like to think that a lot of the judges out there, they appreciate the service. Yep. They understand the atrocities that happen in deployments. And so they tend to be just a bit more, I would say a little bit more lenient in deciding those cases. Then, non-veteran mental health cases, if there's diagnoses of schizophrenia with hallucinations, those tend to be very, very serious, very severe. Schizoaffective disorder, very severe. If it's pure, say anxiety, depression, and ADHD, now we're looking at some other factors. Is there a lot of work attempts? I would like to see a lot, 5, 6, 7 work attempts, different kinds of jobs, mainly unskilled jobs, little interaction with other people, low stress jobs. And above all, just consistency in treatment, trying different medications, having those medications adjusted, a good relationship with a therapist or psychologist. But we'll take those cases if, those factors are met.
Yeah. They're challenging, no question about it. And, again, you have the right evidence and you get a reasonable judge, they can be approved. PTSD, I agree with you. I mean, I if I can help a veteran, I'm going to do it because they've, put their life on the line for me. I will say that I find that many judges are, if somebody's talking about something that happened to them, it's different than if they saw something. I don't know. I've had people come in and say, well, I was around a lot of dead bodies and it really freaked me out. I've got nightmares. That a lot of times doesn't really move the meter. If they were in an armed, a vehicle and, their buddy next to them got the head blown off, might be a different story. So it just kind of depends also on what happened to them and how long were they deployed. Was it, 8 months of just being under constant pressure, constant, threat of death, as opposed to a couple of weeks, things like that. Kathy said she had an MRI and EMG nerve test done October 25th, so or done October 20. I'm assuming of October of 2025. So I guess the question is, what were the results of that test? Will they be helpful for you? Okay. What would it take to reverse the 2017 rule change that made SSA decouple its final determination from the decisions of other government agencies such as the VA? Correct me if I'm wrong, but I don't think the VA determinations were ever, as long as I've been doing this, ever bonding on Social Security.
I agree with you because it's such a different standard.
Right.
So I don't think they're. I may be wrong, but I don't recall a time where.
Yeah, I'm not familiar with that 2017. Maybe if you can give us the rule, but I'm not familiar with it at all. Baxter's the one with talking about seizures. I had EEG showing beta activity, MRI, high frontal. So again, this is objective evidence. I'm not sure what all these things mean, but it does suggest objective evidence, which is certainly to your favor, and that's a helpful thing in a seizure case. Would you mind? Okay, so I think you've got a question here. Someone has lumbar spondylosis, which is essentially degenerative disc disease, cervical spine disease, and spinal stenosis with disc flattening, spinal cord, and sciatica. Does that person have a case for SSDI? Again, you're giving me diagnoses. The question is, what are the functional issues? Now, having degenerative disc disease, it can be mild or it can be severe. Spinal cord flattening, again, how severe is it? And then are the functional limitations consistent with that objective evidence? That's really what a judge is going to ask. So if you've got spondylosis, which is the same thing as degenerative disc disease, and you're saying I have complete numbness below my knees, not really consistent, okay? If you have significant spinal cord impingement and you have numbness below your knees, that is consistent. So it kind of depends on what the MRI evidence shows. So the conditions you're talking about, again, it's how severe are they? How do they affect your functioning? Okay, Ricky 340. Good evening. Thanks for all your. Sure, we are happy to do it. Big Ta. If it's been since July of 2020 since you worked at SGA, do I need to fill out the work history form since it's been over 5 years? Well, if you have a hearing, well, I think you're the one who was on appeal, but if you have another hearing in 2026 and you have not worked, you would probably just fill out the form saying no. Normally they're going to send you a form, and if you've had no work since 2020, that's more than 5 years, you would just put no work since 2020. I'm not a big fan of just saying don't fill it out. I think you need to respond to it. Again, if you're represented, your lawyer could respond saying, we received this form, the claimant has had no work since 2020. I would look at the earnings record in the file that your attorney will have access to and confirm there's no earnings being shown. Every once in a while you see a situation where either A, unusual, but it does happen, somebody else's earnings get posted in your earnings record, or B, there's something showing up, long-term disability, something else is showing up. So you want to make sure that nothing is showing. But again, if I was your attorney, I would just respond to the request saying there is no work in the last 5 years and you don't need to reveal anything else, I think. Haq Assad, is there a framing mindset for responding to the ALJ's question, sit, stand, walk, push, sustain? I think the biggest thing is specifics, Haq. The biggest thing is 5 minutes, 10 minutes, 30 feet, 15 pounds. You want to stay away from not very much and not very far. That would be that's something I tell everybody till I'm blue in the face. You got to do that. Second thing would be, in terms of, like, say, standing and walking, generally speaking, if you've got a back issue, significant back issue, your standing and walking is probably going to be limited to 100 feet or 50 yards or something like that, or 10 minutes. if you say you can stand and walk for 3 hours, that's not much of a limitation. So I think that's what kind of judges are expecting to see based on your limitation, but being specific is the real key. Jeff, Sydney, any thoughts on that?
Well, with sitting, I always kind of frame it with clients to let them know that we're talking about sitting in an upright position. You're not reclining your legs at all. And it's in the context of an 8-hour period. And then if you are only able to sit for, say, 5 or 10 minutes, explain why. Explain what is happening after that 5-10 minute span that is causing you such discomfort that you're no longer able to maintain that position. And I'll usually encourage clients, and we'll prepare them before the hearing to think about descriptive adjectives to describe the pain that they're feeling. Be very specific where you feel that pain. What does it feel like? Where does it travel to, perhaps? Really, plant in the judge's mind, certain key words to punctuate the reason why you can't sit for X amount of time.
Yeah, I think what you're saying, you're painting a picture. You're painting a picture for the judge about, here's a person who, through no fault of your own, has these medical issues that limit you, and that this is what happens if you overdo it, and this is how much you can do comfortably, and that you've got to take rest breaks during the day, and you've got to get your legs extended. You can, in an office chair, you can only sit for 10 or 15 minutes. You're sitting in front of a computer, your neck starts to ache, your hands get numb. You're just painting a picture. You don't want to sound like a complainer, so it's a fine balance. But on the other hand, you're saying, this is what I got. This is what's going on. All right, Kathy says, MRI and EMG in late 25, very favorable CE exam. Does this impact transferable skills? Absolutely. Absolutely, because those objective tests are going to give rise to specific limitations and pain, and realize that pain is going to impact transferability of skills. If you have significant pain or medication side effects, these are called non-exertional impairments. And so if your case is primarily based on exertional impairments, like neck and back pain or mid-back pain, to get rid of transferable skills, you need to show non-exertional problems that would make skills not transferable. Chronic pain, interferes with focus and concentration, persistence and pace, medication side effects, again, interferes with focus, concentration, mental processing. Maybe there's some depression, non-exertional, but it impacts with emotional stability. All of these things are going to erode transferable skills. That's how I make the argument. Would you approach it the same way, Jeff?
Yeah, most definitely. Depending on the nature of the CE exam, I mean, if it's say it's a favorable psych CE exam, there may be no transferable skills, because you may find a person is reduced to an unskilled level. So some variables there, but yeah, I agree.
Now, what do you know? A lot of times I'll look at the initial and recon decisions, and let's say the adjudicator found the person limited to unskilled work, but denied the case to step 5 on the grounds there were other work they could do. Is that something, and I assume you use that, how important is that at a hearing for a judge to see that the adjudicator found them limited to unskilled work? I mean, the judge is going to make a new determination, but I'll rely on that. I'll mention that in my brief, because I think it's important. Would you agree?
Oh yeah. I mean, this is a medical opinion from an acceptable medical source that reviewed the file, and based on the evidence before that provider, they determined that this individual has deficits with memory, concentration. They're reduced to simple instructions, simple work-related decisions. Usually, a supportive DDS opinion isn't very common, and I do think it's important that as reps, we lean on that when we have it as part of our arsenal.
Yeah. Well, again, sometimes, when I find the two things that I look at the DDS opinions for, one would be if they find the person limited to unskilled, and it does happen, or they found they could return to past work that is, guess what, outside the 5-year look back period.
Yep.
So, hey, there's no past work. that they could do that the DDS found. A judge is going to make a new determination, but many times there's no past work at all, that they were denied at initial recon because there was past work in that 5-year look back. By the time you get to a hearing, it's now, 2 years later, no past work. And that happens a lot, happens an awful lot. And you got to be aware of that, I think. All right, we have time for just a couple more because we're getting close to our 2-hour mark here. Let us ask, I was approved by the medical and federal review only to have the local SSDI person deny my appeal for reconsideration. I doubt they read my job descriptions with the judge hearing. So I'm not sure if I understand the question. You're approved by medical and federal review. I don't know if that makes any sense. I mean, I'll just say big picture, a judge at a hearing is going to make it what they call de novo review and look at everything with a brand new pair of eyes, not being bound by anything done at initial or recon. But I'm not sure when you say medical and federal review what that means. Does that make any? I mean, am I missing something? Do you understand what they're asking?
I'm not sure what the medical and
federal review
actually means, but the judge is not bound by any prior determination. The judge is new set of eyes, making a brand new decision, and judges typically go through the same gambit of questions to learn about what are the severe impairments, what are the functional limitations. So it's basically a brand new slate when you get to a hearing.
All right, and this is the second part of Martini shot. I suspect the person who denied my original application of my appeal, even though medical review, federal review are favorable, no clue, not read my job descriptions. Let me just address this kind of big picture. Nobody likes to get denied, no question about it. Nobody likes it when an adjudicator, someone who you've never met, someone who's never seen you, and just looking at medical records denies you. In what you're writing here, you're kind of assuming kind of nefarious intent to it. And I don't think that's a good way to look at it. I mean, the adjudicators are doing, they're making the decision based on, the direction they've been given, the decisions or the opinions of the medical specialist. It's not personal. They don't know you, and again, they're under pressure to only approve people that are clearly, should be approved. And a lot of them don't have a lot of time to work, but there's not usually anything nefarious in there. And I'm kind of getting the sense here that you're sort of seeing this as a personal attack on you, and I think that's not a good approach because a judge is going to not find that compelling. Would you agree? I mean, would you guys agree? That's just I don't think you want to take that tack where it's sometimes the judge lied. The judge didn't lie. The judge just made a decision that was not favorable to you. That's not the same thing as that's personal against you. Okay, time for a couple more here. All right, 1 grand mal seizure 5 years ago. Lost consciousness, taken to the hospital for 3 days, take daily medications for life, was fired, no work since, using medicine, brain fog. Again, this is an example of a seizure case. You had a grand mal 5 years ago. It seems to be under control with medications. If the medication side effects are significant enough to make it impossible for you to function in a simple entry-level job, then perhaps you win. But the grand mal seizure part is probably less important other than to explain why you're on these medications, would be my take on this. Okay, let's see if we've got, okay, so Michelle says writing briefs and case outlines on paper, new to actual hearings. Okay, and then that's, again, perfectly fine. Just try to listen to some if you can. Okay. Let's take this last one, then we'll call it a night. Severe rheumatoid arthritis with fibromyalgia, 57-year-old male, works since 1989, applied for SSDI September of 25, denied last month, claims some limitations, able to perform previous work, which is physical security, yet you cannot function. All right, Sydney, this person comes to you. What do you tell them?
Yeah, so I would say that just based on reading that, it would appear that you do have a more favorable chance of being approved based on your age and your diagnoses. However, Security work nowadays has changed, and the concern would be that they found that you could do a position that was similar, but maybe not as physically demanding. However, if you were required to stand and or walk for 6 to 8 hours, or if you were required to frequently lift 10 pounds or occasionally lift 20 pounds, you would have a great shot at approval at the hearing level. You should just work on getting some medical opinions from your providers to demonstrate that you have a light or sedentary RFC.
Yeah, and that would be, so the grid rule. If you look at, I have a website, gridrules.net. If you look at the light grid rules like 202.06 or 202.04, I think, and you've got RA, I think you probably have a pretty good way to argue that you'd be limited to light work or less. And then if you've got no transferable skills, depending on what you've done, physical security, probably not going to have any transferable skills. I think you got an argument. Again, I'm still going to tell you, male fibromyalgia, not my favorite, but RA is, I think a little more, going to give you a little more argument. Jeff, anything to add to that?
Yeah, the severe RA, that tells us he's got the what is it, the positive RNA, or that's the objective there in fibromyalgia. If you haven't had a trigger point exam, make sure you have one of those. And this is a kind of case where, when you're over 55, there is a little bit of strategy that goes into that work history report. The note here says physical security, so make sure you emphasize the heaviest weights you'd have to lift and carry as that security. Maybe that gets classified as a medium job by the vocational expert, and you can grid out at the 202.06. Yep. If, let's say, it was more of a lighter security job and there's difficulties in mobility, try to get a cane prescription from your doctor, because that could get you to sedentary, and then you'll grid out at the 201.06.
Yeah, and just one quick point you raised, and I think it's worth mentioning. At the state agency level, the state agency will identify, many times they'll identify jobs using a DOT code. Many times at hearings, the VE will come up with a different DOT code, which might be more or less restrictive. I may offer a third one. So, I'm going to look at that person's, job description, and you look at the DOT, and I'm not a vocational expert, but some jobs are what they call composite jobs, where they may include 2 DOT codes, and the judge has to look at the most limiting or the most physically demanding of those jobs when they figured out whether you could do past work, again, for grid rule purposes. So, it may be that the job, is described one way, but there's another DOT code that's closer to what you actually did. Even though the job description may have been, physical security, maybe there's another job title in the DOT, which is medium, that really describes what you did. So just things to look at. And again, when we're preparing cases, we're looking at what the state agency did, but you got to sometimes get creative, and you can't take anything at face value. Just because the adjudicator called it a particular DOT code doesn't mean that's the DOT code. And just because the vocational witness calls it a certain DOT code doesn't mean that there's not another one that could apply, or that that there's a composite element to it, that there's a second code that maybe part of that job is involved. So I will just say this: when you're filling out your work description, your work history form, be very careful about and be very specific of what you did, and really emphasize the physical part of it. If you once a quarter you had to lift 75 pounds, put 75 pounds is the most you had to lift, because that's part of the job description. Even though you only did it once every 3 months, you had to do it. So that counts. And I think people overthink it and say, well, I only have to do that once every 3 months, I'm not going to put that down. No, you got to put that down, or I got help. So, no, you put it down, because that was you're supposed to be doing it. Or you did it at one point, then you stopped doing it. So anyway, all right, I've been blabbing enough here. Any final thoughts? Let's start with you, Sydney. Any final thoughts about some of the questions you've got, or about how to best approach disability cases?
Well, I just want to first thank you for having Jeff and I on here, and we'd love to come back if you
Sure.
have any additional questions for us. But
Yep.
as far as disability cases go, just be sure that you are being treated for your conditions, that you are relaying all of the symptoms that you experience to your providers, and that you are doing your due diligence in filling out any forms that come in and ensuring that you are attempting to get disability assessments completed by your providers. Those go a long way for cases.
Yeah, I would agree. A statement from a doctor and a functional capacity form, a narrative report, medical source statement addressing vocational issues can really make the difference. Jeff, any final words, and also tell people how they could reach out, where they can find you online.
Sure. Well, first, thanks, Jonathan, for having Sydney and I on.
Sure, absolutely.
First, I have to acknowledge Sydney. She's been with Desert Disability for just over 4 years. And I remember when she first started, I had her watch a slew of your videos, actually,
Okay.
Jonathan, as a little entry point. And then to see her flourish in her role as a hearings paralegal, and then to take and pass the EDPNA on her first time and perform extremely well on it. I'm very proud of you, Sydney. It's been remarkable to watch your professional development, and I'm very glad that I've been a part of that journey with you as well. Jonathan, I myself, when I got into this area of law, you were one of my mentors. I watched practically every single video you had on your YouTube channel. I watched other attorneys' videos, and the reason why I gravitated towards yours is because of how natural you are. And also they're shorter videos, so it keeps the limited attention span these days. But you could tell right away in watching your videos that you just knew your stuff. You're an experienced attorney, you've been doing this your whole career, and you can see that right away in your videos. So I want to thank you for, not just making all these videos, but, for really, the type of person that you are. You're paying it forward through your channel, and I'm a product of that. So I wish to thank you. And
thank you very much.
The audience listening, there are, when it comes to that work history report, here's my final tip. Some people, when they fill it out based on how they last performed it with potential accommodations, where they might not have, performed that job throughout the entirety of that career, but rather how they filled it out in the last month or so. That's a big mistake, because usually you're going to fill that out without highlighting those heavier weights and or the standing and walking requirements. So just make sure you fill that work history out, highlighting those, those heavier weights, especially if you're 50 or older.
Very good. I think that's great advice. Well, thank both of you for taking your Wednesday evening to visit with me. We'll definitely do it again in the near future. I hope, I assume it's probably rather warm out in the Phoenix area, so stay cool. It's kind of warm here. It's very hot and muggy here in Atlanta. It was about 90 degrees and about 85-90% humidity. So I'm sure it's a dry heat out there, but a little warmer. So anyway, we will see you guys soon. And thanks again. And to everybody, thank you all for tuning in. We hope that you found this enjoyable and entertaining, and we'll do it again next week. Take care. Bye-bye.
All right. Bye. Thank
Bye,
you.
everyone. Bye, Jonathan.